Thank you all for joining. Like I said, it's a really critical topic, stressing out family and friends of all of ours across the globe. And so without further delay, let me see. Today I'm going to talk a little bit about the presidential proclamations and the restrictions and how they actually work, the legal challenges. There are tons of legal challenges to the many restrictions that we have, and highlight some immigration news. Some things you may have heard about, some things maybe not. But every Wednesday, we have a Challa weekly Wednesday webinars. I'm on a hiatus. I've been doing this consistently since March, sometimes 2 or 3 during the week. So we're taking a break. We're going to resume after September 16th. And I'm sure there's going to be a lot of news to cover even then. And in between, what we're going to do is make sure that we send the information out on our social media. But we've done a lot of really comprehensive discussions with, remote employment, permanent residence process, how this is the time to get started and what people should do when they're initiating their perm application. Because the job description for the perm application is probably one of the most important. And so understanding the nuances of that. And then there are a number of court cases about H-1Bs that have been very favorable and that can be helpful for someone who has an RFE, because the RFEs have increased ever since premium processing came up because the USCIS is shorthanded. So, if you weren't able to catch one of the webinars before, please, log on to our YouTube channel where we have, all our previous webinars on any particular topic that may interest you. So, and if you like the, YouTube video, please subscribe, comment. I love to hear from people. Share it with the community because, I'm not just, in most of those webinars, I'm not just generally saying this is what it is. I'm actually telling people this is what you need to do. Here's how you can use the court case for your RFE. So the feedback has been that it's been very helpful, and that's our primary goal. I mean, when we started this, that was the primary reason why we started, because we saw how many people were really impacted, and it felt really good. We had a couple of folks where their employer had another attorney, and the attorney was giving them incorrect information, and I actually wrote a detailed memo to one of our registrants and sent her the change in the law that would apply to her case. And she found it, for her, it was a life sentence because she thought she would have to leave the country, and she doesn't have to. So, I say that to illustrate how, these webinars can be very helpful. Now, I think when we're talking about all the restrictions, we have to understand what the president's actual authority is. And under the immigration regulations, 212F gives him broad authority, but it's only the authority for entry into the United States. He doesn't have the authority really to regulate or to legislate, rather, immigration of those individuals already in the US. So for people who had been listening to our webinars, even before the proclamations came out, I was warning everyone. I said, this is what his authority is. I would not travel during this time because you may not be able to come back in. So the first proclamation was just put to place for 60 days. And it didn't impact everyone, just certain types of permanent resident applications. They did have some exemptions, like EB-5 investors, spouses, and children of US citizens who were deemed immediate relatives, which under 21 years, adoptees, law enforcement, armed forces, and special immigrant visa holders. So it was originally just supposed to last for 60 days. Permanent residents didn't have any travel restrictions. And remember, it was only for those who were consular processing. So if you're in the United States, there were no restrictions as to your ability to adjust status, file, and do all of those things. But those that were in process, the permanent resident applications that were in process, who were stationed abroad or living abroad, it impacted them. Then a few weeks ago, we got part 2. It extended the original 60-day proclamation till the end of the year, and it added some non-immigrant classifications to it as well. And the whole premise of this was that because of the high unemployment rate and the current economic crisis on top of the pandemic crisis, that they instituted these additional restrictions, which was H1s, L1s, H2Bs, and Js, and their dependents, right? And so the craziest thing about this is it is only those, remember, he can only restrict entry, only those outside the United States that are not in possession of a valid visa or travel document. And what a lot of people don't know, and it surprised me, but this was one of the common questions that we would get is, I've changed employers, do I need to get a new H-1B visa? You don't. Even if you change employers, your visa, as long as it's valid when issued and it hasn't been terminated, then you can use that visa to re-enter the US. But a lot of people who are stuck are folks that haven't approved USCIS approval. And they just went over for a temporary visit. They needed to process a new visa to come in. COVID hit, everything was shut down. And then just when things were seemingly opening up or going to open up, the presidential proclamation hit. So there is an exception within that talks about the national interest. If a person is deemed in the national interest, are they able to, come in? We don't know what, there is a national interest waiver within the immigration regulations. So they may use that as kind of, a guideline as to how they assess national interest. But you have to know that this current administration is not really very immigration friendly, pro-immigration, oddly enough. So we don't know whether even that discretion will be applied. Now, we do know that in certain circumstances, for people who are stuck, if you can state that there is some sort of compelling interest, like someone had talked about how they suffer from high anxiety, not having their wife next to them was causing them further anxiety. On the basis of that, they're processing the H-4. So it's pretty much on a case-by-case basis, but I tell people to go ahead and make the appointment for the interview, because I think about a month ago there were interviews for October, so they're very backlogged. And it as the cases become worse, you never know when it's going to shut down all over again, because it's per country. Then we heard that so F1 students, that they were suspending the ability of any F1 student to take all online classes. They then revised the rule to say only so if you're outside the US and you're on an F1 and your school is operating online, that's fine. You're grandfathered in under the previous position. But if you are just starting school, they will not issue a visa, because new I-20s have to be issued, and the schools have to say that they are either having all in-person classes, or they're having something called a hybrid. A hybrid model is permitted, and the hybrid allows for some in-person and some online. So the rule for F1s is, before March, when they made the exception, that an F1 student could only take one online class. Everything had to be in person. So when all the COVID pandemic came up, they made an exception and they said, okay, for right now, if you're taking all online, it is okay. For fall of 2020, as you know, the pandemic doesn't seem to be getting any better. They tried to restrict that. There was several lawsuits filed and a lot of pressure from the university. So as a result, they kind of watered it down. But you know, most schools are trying to put together some type of hybrid model because they really want to, you know, have F1 students. It gives them a lot of revenue that they're getting. And especially in certain types of academic fields, you know, the classes would be pretty much empty without F1 students. So I think most schools are trying to find some way to make that work for new students. So the legal challenges, like I said, there were legal challenges to the F1, and now for the presidential proclamation, there have been several, but two noteworthy. On July 15th, it's Panda versus Wolf. And, you know, the motion, you know, basically states that, you know, and in Panda versus Wolf, they were just focusing on H1s and trying to say how H1s should not be part of the ban. Then, a couple weeks ago, the U.S. Chamber, a coalition of trade organizations, businesses, National Association of Manufacturers, National Retail Federation, TechNet, all filed a lawsuit. Oh, somebody's got a question. Let me finish this particular legal challenge, and then we'll go to your question. So, to stop the Department of State, I mean, it's just basically saying that the president can't stop another agency from executing its duties. Oops. And so in the lawsuit, they said they assess that the presidential powers are broad. Everybody knows that. But they do not authorize the president to nullify duly enacted provisions, no matter how broad the president's discretionary powers are. And the president may not take actions that are facially arbitrary and lack a rational connection to the problem identified. Now, the case that we all have to look at to see how the Supreme Court would treat this is Trump versus Hawaii. That's the case, if you remember, the travel ban, one of his first executive orders. There were 3 iterations of that until it finally went to the Supreme Court. But the Supreme Court, although they found it lawful, you know, did say a couple of things. It said that something like national security, because remember, for the travel ban, it was countries that didn't need a visa to enter the U.S. So the government alleged that, you know, the countries were, the home countries were not doing enough to look into the security of its citizens, and there was not enough information sharing with the United States. And so there was a risk to allow these people to come in without a visa. So the Supreme Court said, well, we don't expect that the president and the administration come out and tell us in a public arena why something is in the national interest, national security, because it's a security issue. It's a little confidential. And they also stated that, the issue of national security should not be one that lends itself to full disclosure in a public forum, 1. Number 2, they said that Congress, they look to see, because Congress, the US is a 3-branch system. So you have legislative, executive, which is the president, and then you've got judiciary. So when Congress specifically acts, the president can't take that away because it's exclusively their power. So they said that Congress never really addressed this in the regulations. So the president is not interceding into the area where Congress is active. And the biggest issue is that, and they found that although they said, national interest, we don't expect an explanation, they found that there was a relationship to a reasonable basis for the president to institute that travel restriction. Here, that's not the same. We're talking about the economy. So there's no confidentiality there. And I've said this before, that there is no relationship to what the ban purports to do and the US economy. The lawsuit touched on it a little bit because it talks about how the unemployment rate for computer occupations, for example, has remained historically low. But even the people that are stuck in India, they're continuing to work for their employer in the US because it's most of it's technology. But they don't have to pay US taxes. So the US is actually losing money on that. For L1s are used for multinational companies that are looking to expand in the United States. And without the L1, I mean, that's foreign direct investment. So you're actually taking money from another country to boost your economy. So there's no basis for, what they're purporting to do. And in addition, they talk, the lawsuit talks about how sometimes if you've got a key resource, like maybe you've got somebody in .NET or something, there's a whole bunch of other US citizen employees that are employed because you've got this one resource. So if you don't have that one resource and you're not able to continue that work, then you end up furloughing your other US citizen resources. And then finally, they talk about competition and how, it's a global market now, and other countries are really vying for what the US, the critical resources that we've always had. And so it really hurts us from global competition. Now, I think somebody had a question, so let me see who raised their hand. I thought somebody raised their hand. Was I? If you've got a question, you can, because I don't see the hand raised anymore, but you can email it to me on the Q&A or through chat if you like. So I can answer your questions. But so this is the stance. What happens when there's a legal challenge is, and it's in federal court in San Francisco. So it's a very progressive, court. So if they issue what's called a nationwide injunction, that means it can't be enforced. So I think the hearings are to take place early September. They're probably trying to get it expedited, but I don't know whether they will be successful in being able to do that. So on top of everything else, the USCIS, which is astounding to me because the fees that they are charging just keep going up every year. Anyone that's filed any type of immigration filing knows. So at first they went to Congress and they said, we're going to increase our fees by 10%. And I'll tell you how that's not the case. It's going to actually be more. Otherwise, we're going to have to furlough 13,000 people. So then they were able to somehow find some money. And as a result, I think somebody's got a question. I am on an H-4 visa. My 240 days gets over in 20 days after the I-94 expired. Do I have to leave the country? I'm on an H-4 visa on my 240 days. Did you not file an extension? Did you file an you did, okay. The 240-day rule is as long as you filed a timely extension, that means your status is valid. The 240-day rule is only for those work authorized statuses for to be able to continue the work. So an H-1B that files an extension has 240 days that they can work on that H-1B while it's processing. Okay, so it's from the I-9 regulations. That doesn't mean that they can't stay in the US while it's processing. They just can only work for 240 days. H-4s, on the other hand, because it's not a work authorized status in and of itself, it's only work authorized when they've got an employment authorization. You don't have to worry about 240 days. So you do not have to depart the United States. You can stay here. Please don't depart, because we don't know when we can get you back in. So you are okay to stay while your H-4 extension is pending. I think there is somebody with a chat question. My wife's H-4 is denied for not showing up to the biometrics. We never got a letter to attend. USCIS said they sent the letter in February. 150 days passed after the I-94. Can she apply for and stay on the visa? What if the USCIS denies it again for the motion to reconsider? We have 4 kids. We are anxious in COVID. Oh, I'm so sorry to hear about that. You know, I would refile. You know, you may have the motion going. Also do a refile. Do it under premium and ask them, you know, tell them that, you know, you'd never received it. And you may not have, because if it was in February, they stopped issuing biometrics appointments sometime mid-March. So it's very likely that you didn't get it. And I would put it back on them and make a very strong argument. And there is a provision within the immigration regulations that allows for the USCIS, in their discretion, to approve a petition when it's been filed late. Now, she won't be able to file it premium because it's I-539, and I suspect that your H-1B has already been extended. But, you know, try the motion to reopen, get a supervisor to, I don't know if you've been able to get a supervisor on the call to, the service can also do something where they, on their own motion, they reopen a case. If you can make enough noise. Because if she files a new petition, it's going to go through a very slow process, and you're not going to get a quick resolution of that. But I think if you can get a supervisor on the phone, if you filed in February, I don't know exactly what the date was, but if you email us at info@challalaw.com, I can tell you the date that they shut down biometrics. But and we know what my team would know what the processing time typically is for biometrics to be issued. So it was probably right around the time of the COVID shutdown. So they should reopen the case, reopen the matter, and you know, issue a new biometrics. So I would try that. And like I said, make some noise, talk to a supervisor. And sometimes when you do that, you know, you could probably get it addressed. So I think we've I think we've answered all the questions. So next, a fee increase. They said they were only going to increase it by 10%, but they've actually increased it almost 20% across the board. For naturalization, it's ridiculous. There's an 80% increase for naturalization cases. That's because they want to discourage people from becoming U.S. citizens. Surprise, surprise. But these fees are not effective until October 2nd. So if you are thinking about naturalizing or filing an extension and you are able to do that, or any type of immigration filing before October 2nd, I would do it so that you're not subject to the new fees, which may be substantial. Okay, a federal judge in New York has temporarily blocked the Trump administration for the public charge rules, but I believe it's gone to the Fourth Circuit, and they may, allow it to move forward as it goes up the pipeline. Just so, for those who have not been, you haven't signed up for my seminars and stuff, some of the things that are not subject to the public charge is unemployment benefits. If you're an H-4, if you're an H-1B, remember you only have, if you're terminated, you only have the shorter of either 60 days or whenever your H-1B is going to expire. In that period, you can get unemployment. And it's not deemed a public charge because we pay into unemployment. So that's not a public charge. And a lot of the COVID, the CARES Act, many of those provisions are not subject to the public charge issue either. So the president keeps talking about how they're going to, and I think he is, because he's stated on several occasions he's going to try to, through the presidential power, and he wouldn't be able to do it solely through the presidential power. It'd have to go through notice and comment. And notice and comment under the American Procedures Act, because that's what DACA had to do in order for DACA to be effective. That means they have to issue a public notice, the agency that's enacting the new regulations. They have to give at least 30 days for the public to comment before they can issue the final rules. So, he's stating that he is able to, he says, DACA is allowing me to, the DACA decision is going to allow me to put forth a merit-based system. It's not going to be any, although people say that it may be like Canada's and Australia's, we don't think that that's how it's going to be. It's basically going to be to really restrict people with the merits. So there's a lot of things that they've been saying that they wanted to do. With the H-1B salaries, they wanted to institute rules, increasing, because right now it has to be the prevailing wage, but they want another threshold, a higher threshold than the prevailing wage. They've talked about how they want to retool the lottery system based on how much a person is getting paid. They wanted to eliminate the ability of placing an H-1B visa holder at a third-party site. So we think that there may be some of those restrictive elements in his merit-based, proposal, but I'm not too worried about it because it's going to be struck down. I mean, he's not able to legislate, and that's pretty much what that would be doing, would be legislating. There's a card production delay, and there's a couple of lawsuits against that, including authorization cards and green cards that should be issued. There is a tremendous delay. There was a suit recently that said that the USCIS has to issue it within 7 days of those that have been pending for a long time, but it's probably fallen within deaf ears. This is one of the issues that came under the radar that was a little concerning to me. and it's changes to the discretionary authority of the USCIS adjudicators. And what they're stating is that they're reminding the adjudicators that, hey, here's a long list of areas where you've got discretion, basically meaning here are ways you can deny cases. And here is your area of discretion. So I think we are going to see more problems down the pipeline. But if you remember, I had talked about earlier that there have been 3 federal court cases where the judge has basically said that the USCIS policy is, in denying these types of cases, incorrect. One of them had to do with 2 of them had to do with specialty occupation, and saying that one of the bases that we were seeing is the USCIS uses the Department of Labor's occupational codes in assessing whether something, and then the occupational codes are connected to an occupational outlook handbook that talks about what the education should be in certain fields. The problem is, this is 20 plus odd years old, and with technology growing so much, there are a lot of job titles that are not within those 20 some odd job titles that they have. And if it's not within the job titles, it falls into a category called computer all other. Well, computer all other can be anywhere from, you know, a software engineer to someone that does, user interface work. You know, it's across the board. So computer all other doesn't state any specific education for the job, because it's supposed to be an umbrella like classifications. So the federal courts really thought it was ridiculous for denying certain cases where it was clear that the minimum entry into the position, which is what the criteria is a bachelor's degree or its equivalent. U.S. embassies and consulates are supposed to resume work, but I don't think anyone is getting appointments anytime soon. They are issuing emergency appointments, but that's on a case-by-case basis. I think someone's got a question, so let me. My old I-140 is revoked in July 2016, which was approved in January 2015 with the priority date of August 2013. After I joining a new employer in May 6, can I still port the priority date? If yes, what's the best process? I have my immigrant petition document from FOIA that states the priority date is 2013 and has a stamp of an approval. Yes, you can. Good news. I'm so happy when I can tell someone something positive, because a lot of times, you know, there's not a lot a positive that we can say. You can, in 2017, the USCIS, I think it was 2017. Well, 2017 was finally published, but it was around 2015 where the USCIS clarified all the issues regarding portability of I-140s and, you know, your priority date. And they stated that even if your employer revokes your I-140, you can still use that I-140 to continue getting extensions on your H-1B and to port your priority date. And the best way to do that is when you file for your new I-140, you still have to go through the process again. But when you file for your new I-140, you would just show proof and make sure your lawyer, we kind of put it in big bold letters in our cover letter and say, priority date should be such and such a date. And so they on your new I-140 approval, it should reflect your previous priority date. So good luck with that. That's great news, especially with the long queues. I know it's a big issue. Let's make sure that there's Okay, somebody said, can you guide us on the printing of green cards? Yeah, they were just delays in the printing of the actual green cards when somebody was approved, but that has been addressed. So, hopefully they will, through a court order, they are required to print them more expeditiously than they were before. And let me see. What are the advantages apart from the reduced fees? Well, you just don't know in the pipeline, what kind of restrictions are going to come up. So things like if you've ever wanted to file for your brother or sister or siblings and they're overseas, you probably want to do that now because it's a category they've talked about eliminating. You want to file for your parents. This is probably a good time to do that. For the N400, the main advantage is the fees. And also, like I said, we just don't know what type of additional changes are going to come down through the presidential proclamation and through, the USCIS. I think anything that they would try to do would have a court challenge to that. But if you are eligible for your citizenship, I'd file it now if you can. I recently received an approval for my H-1B extension. My dependents still haven't gotten approval for their extension, not even a biometrics done. We probably have 90 more days. Yet the 240-day rule does not apply to dependents. And they're just starting to get the biometrics going for people who filed. So remember, it was stopped until I think it was mid-May when they resumed. So they're backlogged. They're backlogged with everything. But the 240-day rule does not apply to dependents. It doesn't even apply to H-1Bs in terms of status. The 240-day rule is only the limitation on which the primary beneficiary, the primary visa holder, which is either an H-1B or an L-1, can continue working on that status while the extension is pending. So the 240-day rule is not a rule that pertains to you staying in the country. It's just for work. It's an I-9 regulation. It's within the I-9 regs. So it allows a person to continue working for 240 days while their petition is pending. So you don't have to worry about your dependents. They're not subject to that. Could you throw a light on green cards that were to be mailed in April 2020, still not mailed yet due to COVID? When can I expect it? Well, like I said, there's a court order that, the USCIS start issuing them as quickly as possible. But like I said, it's almost as if they've fallen on deaf ears. I don't know. I have not heard of any expeditious processing of that to date, but they are ordered by law to start issuing them very quickly. Let me see. Can we see the EB2 priority movement in October bulletin due to the impact of family base? Not sure. I know that they have stated that EB1 is most likely going to be current because remember, there's a backlog even for EB1. But you'll see some jump in October because the USCIS, their calendar year is from October to October. But it is hard to predict that how substantial a jump we will see. To continue the presentation, Senator Durbin again resurrected the bill, Senate Bill 386, to address the backlog issues. I Congress, I don't know whether they'll really be doing pretty much anything to date. And I'll continue to answer questions, but before I do, I wanted to really thank the GRTA for inviting me today and doing this great work for the community. I think it's wonderful that you all have organized this so that information can get out to all the people that's necessary. So I thank you very much for hosting me and organizing this today. And let me see, we've got another question on chat. Can you provide guidelines on employment details to be filed for self-employed 1099 LC owners in this? Can you provide guidance on employment details to be filled in for self-employment and LLC owners on the N400? Also, how are employment breaks for family reasons to be stated? You can just fill it in as you would any form that you're self-employed, and you can either list the LLC and state that that's your employer. However, it's your payroll is showing. If you're a 1099, so even though you have an LLC, I would imagine that you're not being paid by your LLC, but you're just getting a 1099. Or you can say you're self-employed. It depends. Whoever is the actual payroll. So if you're paying yourself and your pay records show that you're paying yourself, then you're self-employed. If your pay records show that the LLC is paying you, then it would be the LLC that is your employer. So that's how you would state it. And there's no problem with breaks related to employment on the N400. You could just say, just like you told me, that it's for family reasons. So it shouldn't be an issue. I'm just checking to see if there are. I'm on an H-1B. I have an I-140 approved with a priority date of December 2017, but my employer says to file an EB1 category, I should be an L1A. Can I apply for L1A? If the new L1A gets denied, what happens to my current H-1B? You don't have to be on the L1A per se to apply, but if your L1A is denied, and it shouldn't be denied, but you would have had to have worked in the overseas organization for at least 1 year out of the past 3 years. So if you had a priority date of 2017, then I'm going to assume that you entered before 2017. So it may be more than 3 years that you entered. Why don't you send me an email with some of your details at info@challalaw.com, and that way I can tell you, what your options could be and what you should be doing. And we've got a COVID resource page with all the COVID information. Like I said, if you get a chance, subscribe to our YouTube channel. So even if I'm not doing the webinars every week, we're still posting different mechanisms, different tutorials and stuff on our YouTube channel. And email us at info@challalaw.com if you've got any questions. For the last question on the L1, email me with your dates of entry and whether, what was in what capacity were you employed by the international company before you came here on an H-1B. And that would Yes, and so then I can, guide you better than just giving you generic feedback. But again, I want to thank everybody for taking time out of your busy Sunday, and I hope this was helpful. If you've got any questions, like I said, email us at info@challalaw.com, and just know that things are going to get better. It seems very dismal right now because almost every day you pick up the newspaper and there's something, negative in the realm of immigration, but things will get better. And enjoy the rest of your Sunday. Thank you again. Thank you, the Greater Richmond Telugu Association, for organizing this, and you all take care. Bye-bye.